What's up, guys? I hope you're doing well. It is Friday, August the 4th. I knew that before 6:30 p.m. today, for sure. Friday, August the 4th. Sashina, we'll do the heist together tonight, okay? We'll make it happen. We will do it. Tonight will be a bit of a working group. Let's call it that, where we'll get shit set up. Um, I hope everybody's doing well. I was off yesterday and I appreciate being able to stop doing this when I want to, like yesterday. And I had a friend's birthday oh God, Sashina, remember when I used to do that? I'm really good now at not getting my voice echoing again, but I used to do that quite a bit. That was like pro move at the beginning. Um, Anyways, friend's birthday, I cooked for them, as is my move, and I had a good time. Um, what else? Okay. In fact, I don't even need to talk to anybody in here about this because I personally know all of you are already subbed to Credence and Mikey, but they are so close to 20K that it's sort of hurting me personally. So if you're not, or if you do have alternate accounts that you forgot about, if your husband, wife, girlfriend, boyfriend, dog has their own fucking YouTube account, if you could just go ahead and sub, that would be grand because we like to help our friends. And they are very, very good friends. But like I'm seeing here, like literally Vicky, Sashina, Courtney, um, Beverly, like I see y'all there every day. We'll wait till later when there's some noobs here. Somebody remind me. Hi, Grammy. Rita, I hope you're doing well. Jonathan, hope you're doing well. Cellulite yoga pants. It's really hot. Oh, I have a plan, but sometimes I forget about the plan. But I then recall the plan. So we're gonna start with my lesson of the day, trying to learn about Americans. So we're gonna go do the weather because it's hot. You guys, this is not a glossy dew. This is me gross. Like, it's hot. Okay. And so, like I told you, I've transferred my phone into Fahrenheit so that I can become a little bit more in tune with you guys. You talk about certain things so much, I just have to. So, okay, but I still don't get it. Means nothing to me. So we're gonna go ahead, and I'm not good at math, so we can't just give me the conversion. We have to just do this every day. So it's 75 degrees, 75 Fahrenheit. Now, let's go ahead and just Celsius that. 24. Okay. Okay. Okay, here's the problem. 24 in where I live, West Coast BC, is pretty much like saying 100 degrees. Like, I know what 100 degrees means. When y'all say that, that means really hot. But that to me is like 24 degrees, or apparently 75. Like, what the fuck is 100 then? Because seriously, somebody find, oh wait, is that like, we've already done this. I do this every time. I still get baffled. It's like 32, which is still very hot. Beyond hot. um, we're not gonna watch, maybe we are. This guy, I started this. Oh, sorry. Does anybody else have anything else to teach me today? 75 degrees, you like that? There's always a breeze here, so that's helpful, but that's quite warm. Nobody has AC, like real AC, and I definitely don't have it down here. Um, it is also a holiday weekend where I am. It's British. 37 degrees. See, 37 degrees. Like that sounds like yeah, 37. It's never 100 degrees here. I bet if somebody looked, we had a heat dome like 2 years ago, and I'm a lucky person, you know. And I had it's BC Day because I live in BC, so it's just British Columbia Day. Hi Katie. Uh, yeah, we have a 3-day weekend virtually every month, and we have non what they call like non-statutory holidays as well that are long weekends. I used to be a government worker, so you get all of those holidays plus more. But my ex-husband, even better, he is in a union, a better union than mine was, and they got something called the birthday stat. So they literally negotiated an extra stat day in their um I was like, is that him texting me? That would be weird because there's only 17 of you here, and if he's one of them, no. But yes, I was a government worker. I used to work for the Attorney General's office. And I've worked for multiple governmental agencies, municipal and then provincial. But the his union negotiated a birthday stat. So every year, what that basically resulted in was an extra paycheck in December, and they already got paid weekly. So it was good. It was smart. Kudos to them, you know. Hi, BCM, Tin Man, Williams here. I hope everybody is doing very well. Like I've said before, it is Friday, Friday. Actually, there's a picture from one of my government jobs when I worked for the transportation company, which is why I always laugh about um, when they ban people from MARTA in Atlanta. I find that just hilarious because, in fact, one of my jobs used to be participating in meetings about people that were problems on the bus, like people that caused issues. They have meetings about these people that are in front of the judges because you have to deal with it. But in reality, it's extremely difficult to enforce a ban of somebody on a public transportation system. If you think about it, the drivers already have a lot to do. And in fact, here we don't want the drivers to be enforcing fare evaders, anything. A driver is to drive. They don't have to worry about anything else, and they're never going to get in trouble if they don't worry about anything else. That's not their job. And so, in fact, teaching drivers not to engage people and to just call it in or move on is one of the big things about transportation and like de-escalating. But when you think about it, it's virtually impossible to put, maybe you could do it in a very small town or on a specific route, but you can imagine, how would you enforce without facial recognition software like somebody being banned from public transit? Like and I guess it's not public transit in Atlanta, which is why it's a little bit different. Here it was very rare, if ever, that somebody would get an official ban, and it would maybe last for a short while. And that's because, again, it's just not enforceable in the same, like, in an, like, reality wise. It might be great to write down on paper and hand out left, right, and center, but it doesn't help. Not to mention the buses where I live have 8 to 10 HD audio visual cameras inside and out, and they record everything. So don't fuck around on the bus. People watch. That's the lesson I've learned. Okay. And I personally have never been banned from transit, William, and I've talked about my de-escalations. You do have facial recognition in your cameras in the States, Jonathan. I used to work for FLIR, Forward Looking Infrared, headquartered in Atlanta, but they have a sub office here. And the software that we used was facial recognition tracking software that is employed in airports, banks, casinos, military bases, etc. So yeah, of course. Very cherry, welcome. Katie, what did you say earlier? You said you were wondering where I went and you found this new channel. You watched the first 9 hour stream. Oh shit. Oh God, I love you. Thank you so much. I have abandoned the other channel in a way, but not. I do drive. Yeah, I know how to drive. I used to sell cars. I've had every job. But yeah, no, I of course know I know how to drive and I drive. But the town that I live in, and gas prices, the way they are, like the bus is not a really bad option. I walk a lot. I'm in fact dealing with the normal Fitbit rash that I get every time I get a new Fitbit. The status of my original channel is demonetized and unavailable for remonetization for the next 3 months. So, and once available, unable to tell what the problem is. So it's just not feasible. I have hundreds of videos on that channel, both live. I have it back. I have control of that channel. I could post on that channel if I want. Um, I the problem is that I feel really weird putting effort um and and energy into um the channel when they can't just say like, hey, it's because of XYZ videos and this that we demonetized you. So in reality, and I've said this before, and this is a great lesson to learn for people, when I first started on YouTube, I uploaded many, many videos on as unlisted because I used it in a somewhat storage sense. Bad idea. But what that means is there's literally hundreds of unlisted videos I have on there that could also be triggering the demonetization issue. However, I was monetized with those before, which is why I've sussed it out a little bit further. However, my point is it's a bad idea because everything you upload to YouTube has to follow terms and guidelines. So that means they don't want unedited videos, basically, if you didn't make it. So the reused content, it's why it's quite baffling to me because I've hundreds of hours of straight court content with nothing edited in it that didn't seem to get flagged at all. But then when I started poorly editing videos, which is what happened, like I just tried, but I did a very bad job. Um, they were like, well, no, actually that's not good. So that's really where we're at. I Yeah, but I, yeah, I got those subscribers in 4 months. So I'm not too worried. I am a cat. I land on my feet. No. In reality, what I want to be able to do is eventually monetize this channel and have a really strong knowledge that every video I've uploaded has complied with the terms and conditions so that I have no question in my mind with this channel going forward. And I think this is as good a time as any to do that because, again, it didn't take that long to do it on that channel. And the it's just a better peace of mind going forward. I'll never delete that channel and I'll always leave up those videos. And if I figure out a way to make it feasible, like I'm thinking about using it as like all where I put all the videos I don't think they'll like, to be honest. But right now I'm just leaving it alone because mostly because I'm a bit of a bitch and YouTube Daddy and I are in a bit of a tiff right now. So I would think YouTube Daddy would want me to be sharing on that big channel too, but that's not what's happening. Um, oh, I know. But the thing about lives is that if the whole channel's lives, then there's no question. And if you watch a live of mine, there's really no question that I transform the content and that I take what could be considered boring or whatever core, and then I transform it with interaction with you guys, with the way that I talk about it and react to it and commentate on it. I'm just not good at editing. I love great edits. Like, I love watching the videos where everyone puts in the memes and the music and all the shit, and I'm like, fuck, I would love to be able to do that. I can't, but I think about it. Crystal, welcome. Anyways, we don't have to bitch anymore. Uh, we can dream big. Wait, it's over there. Dream big. And don't turn around. No, honestly, what is it? Is it a Chumbawamba song? I get knocked down, but I get up again. They're never gonna keep me down. That one. So we've got some court to watch. Let's get going with it. Also, like, again, pressure helps me in some ways. Like, I'm a little more slick these days, you guys. As I fumble. This guy's rattan background is what made me start here. I didn't even read that he's a Spanish interpreter, which we all know is my kryptonite because I failed Spanish, 4 years of Spanish in high school. I can't speak Spanish.
Good
So it
morning,
just rubs it
everyone.
in.
We're here for the Bothell Municipal Court 9:30 calendar for Thursday, the 3rd of August. I'm Judge Mara Rosano. This calendar is being conducted on Zoom. It is also being live streamed to YouTube in order to accommodate the open courtroom doctrine. Anyone watching on YouTube who wishes to participate in a particular case needs to go to the Bothell Municipal Court website, click on the link to video court, and then click on the link to enter the virtual courtroom. Once there, let the administrator know which case it is you wish to be heard on, and that information will be conveyed to me. The official record of these proceedings will be made and maintained by the Bothell Municipal Court. Anyone making a recording without having obtained prior approval of the court may be subject to legal action, including but not limited to contempt proceedings. With that, I believe we are ready to proceed this morning. Good morning, counsel.
Good morning, Your Honor. We have Jordan Mueller in custody, ready on case number 3A05186679. She would like to change her plea to that of a guilty plea. I did go over the plea paperwork with Ms. Mueller, including the constitutional rights that she's giving up, as well as direct collateral and any immigration consequences. I do believe she's entering into this plea knowingly, voluntarily, and intelligently. I would like Your Honor to accept this plea and proceed to sentencing today.
Good morning, Ms. Mueller.
Good morning, Your Honor.
I have a document before me entitled State.
Steven Tyler plays prosecutor, and it outlines the crimes that you've committed.
Of defendant on plea of guilty under your cause number 3A05186679. It has your name on it. It also looks like you gave Ms. Kim permission to electronically sign this document on your behalf. Is that correct?
Yes, Your Honor.
Did you have a chance to read or have read to you this entire document prior to deciding to enter into this plea?
Yes, Your Honor.
Did you have a chance to go over it in its entirety with Ms. Kim?
Yes, Your Honor.
Was she able to answer any questions that you had about it?
Yes, Your Honor.
Do you have any questions for me about the document?
I do not, Your Honor.
All right. We're going to go through this together starting on page 1, paragraph 1. Is Jordan Mueller your true name?
Yes, Your Honor.
Are you 32 years old?
Yes, Your Honor.
Is the highest...
She's a 32-year-old lady. I'm a 35-year-old lady. I miss you, Jenna Marbles, so much.
Level of education, you've completed the 12th grade.
Yes, Your Honor.
Paragraph 4 indicates the crime that you are charged with, which you are indicating you wish to plead guilty to today, is one count of attempted theft in the second degree. The elements of that crime were set forth in the charging document that you received in this case. Did you go through those elements carefully to make sure that they accurately describe the crime you intend to plead guilty to today?
Yes, Your Honor.
Paragraph 5 sets forth the constitutional rights that you give up by pleading guilty. They include the right to a speedy and public trial by an impartial jury in the county where the crime was alleged to have been committed, the right to remain silent before and during trial and to refuse to testify against yourself, the right at trial to hear and question any witnesses who would testify against you. You also have the right at trial to testify and to have witnesses testify for you, and those witnesses can be made to appear at no expense to you. You also have the right to the presumption of innocence. It requires that a charge be proven beyond a reasonable doubt before a finding of guilt could enter against you, and you have a right to appeal that finding of guilt after trial. Do you understand that these are your constitutional rights and that by pleading guilty today, you will be giving them up in this case?
Yes, Your Honor.
Paragraph 6.
Is she under oath already? I don't think she is. Is that what you wonder, William? I'm reacting to y'all. And the live audience, of course.
6 sets forth the consequences of your plea. Did you go through those carefully?
Yes, Your Honor.
Did you make sure that the prosecutor's recommendation that's written in paragraph 6C accurately reflects what they said they were going to recommend pursuant to the plea agreement?
Yes, Your Honor.
But you understand as the judge, I don't have to follow that recommendation or anyone's recommendation.
Yes, Your Honor.
I could sentence you to anything up to and including the maximum allowed by law, which in this case would be 364 days in jail, a $5,000 fine, and 2 years of probation.
Do you guys think that judges like added that part in? Because they always say, I'm a boss bitch judge. And even though y'all work so hard on this, I can say, fuck it. They always put that part in.
Yes, Your Honor.
If I did that, that would not be grounds for you to withdraw your guilty plea. Do you understand that?
Yes, Your Honor.
Also understand if you are not a citizen of the United States, this plea could have immigration consequences.
Yes, Your Honor.
Did you go over all of these consequences with Ms. Kim?
I did, Your Honor.
Has anyone made any threats or promises other than the recommendations set forth in this paperwork to get you to plead guilty today?
No, Your Honor.
Are you doing so freely and voluntarily?
Yes, Your Honor.
Paragraph 11 is a statement in your own words of what you did that makes you guilty of this offense. It reads as follows. On July 20th of 2023 in Bothell, Washington, I took a substantial step towards the commission
To the wards, like, okay, here we go. Sorry, I can't. Because I don't know what she's going to say, and Novi knows what she's going to say. So what's she going to say? I took substantial steps towards the commission. Which crime? Which crime, my friends? Put it in the chat, if you will. It's Bothell, so I'm gonna go with either a theft or trespassing. Those are my two guesses. Yeah, like a theft. Theft by shoplifting, maybe. Although it's a weird way. Also, presto, I did not get off camera on purpose for that. I was lighting a joint. I'm really trying hard not to break all of this. You think shoplifting and possession? You just like it when we are not at in Georgia. We're off across the country today. Hi, Donna.
of theft 2 by intentionally trying to take Home Depot products without paying and with intent to keep them and the property was worth more than $750. Is that a true and accurate statement?
Yes, Your Honor.
Do you adopt that statement as your own?
Yes, Your Honor.
Then to the charge of attempted theft in the second degree is charged here under this cause number. How do you plead?
Guilty, Your Honor.
Guilty plea will enter. I find it's knowingly voluntarily made and that there is a legal and factual basis for accepting the defendant's plea of guilty. Does the city have anything to add to its recommendation?
Sorry.
Home Depot is
Your Honor, no,
extremely
this is an agreed
litigious.
recommendation.
Sorry, we'll go back for you,
Plea of
Stephen.
guilty. Does the city have anything to add to its recommendation?
Sorry, I couldn't unmute. Your Honor, no, this is an agreed recommendation.
Ms. Greenwood, do you have a microphone you can move a little bit closer?
Is that any better, Your Honor?
It is a little bit, yes.
Right, thank you. The city doesn't have anything to add. This is an agreed recommendation.
Ms. Kim,
Yes, I do ask Your Honor to follow the agreed recommendation. If Your Honor does follow with good time, she should be released from this case. I know she has a holdout of Marysville, but I believe that should resolve fairly quickly. She indicates that she already has an assessment done with Evergreen and was waiting on an inpatient bed. She was coordinating that with the inpatient coordinator over there. And she's very motivated to get into treatment as soon as possible. I know this was not directly related to drug offense, but she indicates that she knows that she has that problem and she agrees to be supervised by probation. So I believe that is a good step by her towards clean and sober lifestyle. I do ask Your Honor to waive all non-mandatory cost fees and assessments as she will be focused on treatment. And she does not have a job right now.
so if I'm looking at her history correctly, this is her 6th theft conviction since 2021. So in 2 years, is that correct?
That does seem like it. The city was asking for more time, but because she's agreeing to be supervised by probation for drug offense, city agreed to recommend less jail.
Okay, willing to have a condition of alcohol evaluation and treatment, is that
Correct.
okay? Ms. Mueller, this is your opportunity to tell me anything that you would like me to take into consideration before I pass sentence. Fancy legal term for it is your right of allocution.
Okay, I just want to let you know that I'm very motivated to be clean and sober and get my life back on track. So
I hear that.
Yeah, I heard that too, but I heard it so quickly that I'm wondering if you're high right now. And I'm not trying to be rude, but that's a little methy. Yeah. Oh yeah, Courtney, for sure. I mean, there are people that go in and steal on like order. Like people order what they want, and then the people go in and steal it.
I hear that a lot.
yeah, I bet you do.
Why should I feel that that's really the case for you?
I'm kind of at the end of my rope here, so I don't really have another choice.
So Ms. Kim indicated you've already done an evaluation. Is that correct?
I've done 2 actually.
Okay. And you have you have a bed date, but presumably you lost that.
Correct. Yes.
All right.
I was supposed to go to Prosperity in Tacoma for inpatient.
Okay. All right, because I know that technically the crime is not necessarily drug related, but we all know that this is drug related.
Correct.
And so the fact that you are agreeing and stipulating that this offense was drug related and that you're acknowledging that you need treatment pretty much you're saying without that treatment, you'll probably commit the crime again, right?
Correct.
Yeah, I mean, it's pretty straightforward.
Yeah.
I appreciate that. So I will follow this. I was not inclined to. I will tell you that. I will follow this recommendation.
Thank you, Your Honor.
300, you're welcome. 364 days in jail. 346 suspended, giving you 18 days in jail, but giving you, I believe, credit for 18 days served. Is that correct, Ms. Kim?
No, I calculated that based on good time that she should be released, but she was only booked on, sounds like July 20th is her booking date. So she has what, about 13, 14 days credit.
All right. So it's 18 days to serve, credit for 13 days already served, which, and I say that just because I know how the jail calculates days, and I don't want you to have your hopes up. I think that will be fine. $5,000 fine. I'm going to suspend the entirety of the fine. Based on my finding of indigency for purposes of court-appointed counsel and Ms. Kim's representation, I do make a finding that right now you are indigent, and will waive any non-mandatory cost fees and assessments.
Thank you.
I am going to put you on probation for 24 months, and it is going to be supervised, meaning you have a probation officer to meet with. I will give you my lecture, but it's a short one. Probation officer is your best friend in the court. They are the person who stands between you and me. You come back before me, the likelihood is you're going to be facing at least the potential of jail time, right?
Yes.
If you're working with your probation officer, they will not send you to jail. All right?
Okay. Okay.
Their job is to make my job easy, which means less people on my calendar. So they're going to work really hard to help you succeed. Okay?
Okay.
That's their job.
Okay.
So people look at probation as like somebody who's trying to get them in trouble. They're not. Okay. They're trying they want me to think they're doing a great job. They're the best probation officers in the state, right?
Correct. And so how long will I have to check in with my probation officer?
We'll give you an appointment. Madam Clerk, do we have one at this time?
Yes, Your Honor, it is set for August 23rd at 10:30.
Okay, so it's a little ways out, but that's going to give you time to get your other matters addressed. So August 23rd. Is that a phone appointment or in person?
That is a phone appointment.
All right. So it's pretty easy. Make a phone call, right?
Okay.
What I hear from people sometimes is that their phone gets stolen, which I know happens a lot. All that.
I won't.
We have
I'll make
phones
it.
at the court. Okay.
Okay.
All right. So, have no new criminal law violations for which there's probable cause. Make an appointment with not make an appointment. Sorry, we already made an appointment. Make it to any future court hearings if I do set any. That goes back to keeping your address up to date with the court, especially now. If you're out and you think you're in perfect compliance, but we're not getting the documentation, I will set a hearing and summons you to come in and talk to me, right?
Okay.
You don't make that hearing, we talk like this.
Correct.
Right?
Yep.
May not love seeing me, but you'll have to. It's much better if you are not in custody.
You're not even that late, Melanie. This is the first case. This girl's getting fucking lucky. She almost said the wrong thing there. How long do I have to talk to this parole officer? She just told you that person's your best friend. You should be like, is it okay if I call them 3 times a day? Yeah. Like, she doesn't want you to say, how long until I can stop calling? Like, that's not the right move. But this judge, she likes to suss people out. So Sheena is back. That's true. Presto's here, getting some PTSD from apparently marrying a judge, allegedly. What is everybody having for dinner? What are you thinking, Melanie? I'm West Coast, so you know how we go. Although it is 7 o'clock. Let's keep going.
Right?
Correct.
All right. Now, the big thing. Well, no, let's do the one more easy thing, hopefully. No, do not contact Home Depot. Do not go to Home Depot
No.
for any Home Depot, because
I wasn't expecting that. The big one. Don't contact Home Depot. Like as if she's like writing love letters to Home Depot. Dear Home Depot, aisle 16 and I had some good times.
they undoubtedly have trespassed you at this point.
Correct.
The big thing, obtain an alcohol drug evaluation and follow the recommended treatment. Sounds like you have the evaluation, but I'm going to say that I need you to provide a copy of that to probation within 30 days of your release of confinement. Okay.
Does it have to be, because I got the assessment, it's probably been a month or so. Should I get another one?
Bring that in. If probation wants you to get another one, they'll let you know.
Okay.
It's possible, and it depends on whether or not the treatment, there's a whole bunch of factors that apply there.
Yeah. Okay.
So it may be that you'll have to get another one, but I want you to be following that drug treatment within 60 days of release. Okay.
Okay.
What that means though is that means following it with all the proper forms signed so that the court knows about it and the court receiving those documents. So it's not really 60 days, right? Because we
Correct.
know how bureaucracy works. All right. Get on this.
Okay.
I would love to see you. I would love to not see you because you have successfully conquered this disease, this thing that has control of you, right?
Correct.
All right. So good luck to you. And again, your probation appointment is set way out, but if you want to talk or have resources available, come to the court. All right. Come in.
Okay. Thank you, Your Honor.
I need resources. All right.
Thank you, Your Honor.
Good luck to you.
Thank you.
All right, Ms. Whitaker, yourself.
Thank you.
And thank you, Ms. Kim. I think she's already checked off. Okay.
Good morning, Your Honor. Caitlin Pimentel, President. If we can first address Mr. Galindo Blandon. This is a new booking. Mr. Sepulveda is here to assist with interpretation.
Thank you. Good morning, Mr. Sepulveda.
Good morning, Your Honor. For the record, Pablo Sepulveda, certified court Spanish interpreter, permanently sworn, oath on file. Señor, me presenté como el intérprete. ¿Me escucha?
Your Honor, this is cause number 3A 0570303 on for arraignment.
Su señoría, este es el caso 3A 0570303 y estamos aquí para una instrucción de cargos.
Underlying allegations being count 1, driving while license revoked in the second degree.
La acusación subyacente es el cargo número 1 de manejar mientras la licencia estaba revocada en segundo grado.
Count 2 is operating vehicle without ignition interlock.
El cargo número 2 es operar un vehículo motorizado sin traba del arranque, que en inglés le dicen interlock.
With the assistance of the interpreter, I did go over the maximum penalties with him, with the charges.
Con la ayuda del intérprete revisamos las penalidades máximas con él de los cargos.
We also discussed the constitutional rights he has at this stage of the proceeding. In fact, he was read verbatim the rights form.
También conversamos de los derechos constitucionales en esta etapa del proceso legal. De hecho, le leyeron directamente, palabra por palabra, los derechos del documento leído.
He's indicated he has no additional questions at this time, and so we are prepared to move forward with the arraignment.
Él dice que no tiene preguntas adicionales en este momento y estamos preparados para proceder con la instrucción de cargos.
Good morning, Mr. Galino Blando.
Buenos días, señor Galino Blandon.
Good morning.
Good morning.
You're here for arraignment, so I need to confirm that Haswa, is it Haswa? Israel Gilando Blandon is your true name.
Estamos aquí para la instrucción de cargos y quiero asegurarme de que su nombre es Josué Galindo Blandón o Blandon ¿Que ese es su nombre verdadero?
Sí.
Yes.
Ms. Pimentel has told me that she, with the assistance of the interpreter, have gone over a bunch of information with you this morning, most particularly your constitutional rights.
La señora Pimentel me acaba de decir que con la ayuda del intérprete han revisado muchos de la información esta mañana, principalmente sus derechos constitucionales.
Did you understand all of it?
¿Y usted entendió todo esto?
Yeah.
Yes,
Ms. Pimentel,
señora Pimentel.
Will acknowledge receipt of the complaint, waive formal reading, and enter a plea of not guilty on his behalf.
Aceptamos recibir la acusación, renunciamos lectura formal y asentamos una contestación de no culpable de parte de él.
not guilty plea will enter.
Se asienta la contestación de no culpable.
The court has previously had an opportunity to review the police reports and did make a finding of probable cause. What is the city's request with regard to release and conditions?
La juez previamente ha tenido la oportunidad de revisar el informe policial, sí determinó que existe el motivo fundado para la acusación. ¿Y qué es lo que está pidiendo la fiscalía con respecto a la liberación y condiciones?
Your Honor, the city is not requesting any bail in this matter based on Mr. Galando Blanden's lack of warrant and criminal history.
Su señoría, la fiscalía no está pidiendo una fianza en este caso, basado en el antecedente penal del señor Galindo Blandón.
City is asking for standard driving conditions of release.
Y la fiscalía está pidiendo condiciones estándares de liberación.
Any objection, Ms. Pimentel?
Señora Pimentel, ¿se opone?
There's no objection to standard conditions. We did go over all of those.
No nos oponemos a las condiciones y nosotros ya revisamos todas estas.
Sir, do you prefer to be referred to as Mr. Galindo or Mr. Galindo Blando, Mr. Blando?
Señor, ¿cómo quiere que le llamen a usted? ¿Señor Galindo, señor Blandón o señor Galindo Blandón o Blandón? ¿Cómo quiere que le digamos?
Señor Galindo, está bien.
Mr. Galindo would be okay.
Mr. Galindo, I am going to release you on your personal recognizance on the following conditions.
Señor Galindo, yo lo voy a dejar liberado con su propia promesa a presentarse a tribunales bajo la siguiente condiciones.
You need to notify the court in person or in writing of any change of address.
Usted debe notificarle al tribunal en persona o por escrito si se cambia de dirección.
Have no new criminal law violations for which there is probable cause.
Usted no puede tener ningún nuevo quebrantamiento de la ley para lo cual existe un motivo fundado para la acusación.
Make an appointment with your attorney and make it to that appointment. They
Usted
can't
tiene
help
que-
you if you're not talking to them.
Usted tiene que asistir, hacer una cita para hablar con su abogado o abogada. Tiene que asistir a esta reunión, porque los abogados no pueden ayudarle a usted si usted no está hablando con ellos.
Make it to your court dates, which I'm going to give you in just a moment.
Usted debe presentarse a su audiencia. Yo le voy a dar la fecha ya en un momento.
Do not drive unless you are properly licensed and insured.
No maneje a menos que tenga la licencia apropiada y aseguranza.
And do not drive any vehicle unless it is equipped with a functioning ignition interlock device, as long as one is required by Department of Licensing.
Y no maneje ningún vehículo a menos de que tenga instalado un dispositivo de traba del arranque, que en inglés le dicen el interlock, siempre y cuando así se le requiera de parte del Departamento de Licencia.
I'm going to set this matter for pretrial on August 31st at 1:30 in the afternoon. That will be in person at the Bothell Municipal Court.
Vamos a fijar esta audiencia para su caso, un caso previo a juicio, la audiencia el 31 de agosto a la 1:30 de la tarde y será en persona en el Tribunal Municipal de Bothell.
Trial date will be in the October trial term.
La fecha de juicio será en el término de temporada de juicio de octubre.
But again, your next court hearing will be August 31st at 1:30 at the court.
Pero otra vez, reitero que su audiencia de tribunales será el 31 de agosto a la 1:30 en el Tribunal de Paz.
Ms. Pimentel, was there a request for court-appointed counsel?
Señor Pimentel, ¿hay una petición de que se le asigne un abogado asignado por el tribunal?
Your Honor, it looks like counsel's been appointed in the King County matter that's pending. I don't know that there's been a change of circumstances, so I do believe he would qualify.
Su señoría, a él ya se le asignó un tribunal en el caso que tiene en el condado de King, que tiene pendiente. No sé si haya habido algún cambio de circunstancias, pero yo sí creo que él sí califica.
Just a moment.
Espera un momento.
Melanie, very funny. I have a story about that, my own little getting pulled over one time as well. I think I've told it. Maybe I have. Maybe I haven't. I just would like to. Who is this guy? Pablo something. Let's just give a round of applause. We'll just do F in the chat because we show respect like that too. F in the chat for him. He's
Right.
done a
Looks
fucking
like that
bang up
was
job.
actually
Bang up.
fairly recently, so I will accept the findings by King County. And I will appoint counsel.
Muy bien, parece que esto fue de hecho bastante recientemente, así es que voy a aceptar las determinaciones del Tribunal del Condado de King y vamos a asignarle abogado.
So, Mr. Galindo, I will see you back here at the court on August 31st.
Señor Galindo, lo vamos a ver aquí usted entonces de regreso aquí en el tribunal el 31 de agosto.
I have appointed an attorney to represent you. The contact information will be in the paperwork you received from the court.
Yo le asigné un abogado para que lo represente, o abogada, abogado. Y también la información de contacto, cómo contactar al abogado, estará en un documento, papeles que usted recibirá de parte del tribunal.
Okay, we'll see you on August 31st. Take care.
Muy bien, nos vemos el 31 de agosto. Que le vaya muy bien.
Gracias.
Thank you.
Okay, sir. Go ahead, check yourself, please. I was scrolled up. Come on up. Go ahead, sit there, please.
And the next matter to address with the assistance of the interpreter is Mr. Carranza Escobar.
Su señoría, el siguiente caso a tratar con el intérprete es el caso de Carranza Escobar.
This is cause number 1A02699907 on for pretrial.
El número de caso es 1A0269907. Está aquí para un caso previo a juicio.
Looking into
Sorry,
okay.
okay.
His
Listen, I
history a little bit
approve. I
further.
think you were great,
It
Pablo.
appears that
Caitlin, Steven Tyler, Judge Rosano. But we're done. I'm bored with this now and I don't want to do it. So we're gonna change to different court. Give me 1 second. I'm right here. I found something that I think is better. So let's see if it is. Sometimes, maybe we've seen it, maybe we haven't. I don't know. Huh. That's not what I thought.
If she was so afraid.
No, that's not. Hold the phone. Maybe it is. No, not that lady. We can't deal with that fucking judge again. Sorry. Remember that crazy judge that takes so long? Here we go. Here's we go. This is what I want. Sorry, guys. Not sorry.
that your microphones are muted unless we're actively discussing your case. That helps a lot. First off, I'd like to address the Darcy Francis and Eric Francis matter. These are, its cause number is 23-3-275-08. And it looks like Mr. Zandy, I received a notice of appearance that he's representing Mr. Eric Francis. And I'll ask if Darcy Francis is on the line. Ms. Francis, are you on the line? So I can see an individual named Darcy Francis, and at least that's the name, but I'm not, it looks like she can't hear me. Ms. Francis, can you hear me? I'm just going to send a quick note in the chat.
F in the chat, Judge. F in
Mr.
the chat.
Zandy, are you able to hear me?
I can hear you, Judge. Yes, I can.
Let's see, and I saw your mouth move, but I didn't hear anything. So maybe I need to do something here on my end. Okay, let me try that again, Mr. Zandy.
Yes, I can hear you.
Okay, good. Helps if I unmute my mic or my speaker. So let's see, Ms. Francis, can you hear me?
Okay, yeah.
All right, very good, great. Okay, so we're hearing the cause of Darcy Francis and Eric Francis. It's on today for two motions, a motion for temporary orders relating to parenting plan and child support, and also a temporary restraining order. So I've reviewed those documents. I received some proposed orders from Ms. Francis, and then I just received this morning a notice of appearance from Mr. Zandy that he's coming on to represent Mr. Eric Francis. So just a friendly reminder to Diana Galley, if you could mute your phone, please. Okay, thanks. So as far as proceedings,
We have a TRO? Oh my God. Ugh. That's my phone. Let's keep on.
it looks like I didn't see service of the parenting plan and child support of Ms. Francis. I didn't see that you had served Mr. Francis. So we're not in a position to hear that particular motion today. And then I just wanted to get Mr. Zandy's take on what he thinks the case should happen, or what should happen with the case today with his coming on. And then we'll hear from Ms. Francis what her take is with Mr. Zandy coming on.
I appreciate that, Judge. Yes, of course, where I do and have very recently put in my notice of appearance for Mr. Francis. It's our position to try to piece this together in a very short amount of time. I was consulted with my client earlier this week. He retained formally, I believe it was either Tuesday or yesterday. We put in our notice of appearance right away, and here we are. I have had the opportunity to look through this in my limited time. It appears to me, and of course, Ms. Francis can correct me if I'm wrong, that my client was served on July 21st, which is less than 2 weeks ago, with the emergency restraining order, as well as the docket notice for today's date and the motion accompanying that order. So on that end, we're on for two things today. It's the temporary orders on the dissolution. It's also the restraining order. I would kind of submit that it makes the most amount of sense to hear everything together, to consolidate both hearings. Given that the notice was improper, not timely served on the restraining order, I think it probably makes the most amount of sense just to kind of hold on, keep things where they are for the time being. Put this on a regular domestic docket, and now that attorney's involved, and it looks like this would be a odd number case. I don't know if that's yours or if that's Judge Bassett's, but put it on either one of those and proceed and consolidate, have everything done at the same time in 2 weeks or so.
Okay. Yeah, I think it would be Judge Bassett's. Okay, thank you, Mr. Zandy. All right, so Ms. Francis, so what I saw that it looks like you had served the temporary restraining order on Mr. Francis on July 21st. Does that sound right?
Yes.
Okay. And so there's a longer period of notice that parties receive once you serve somebody, then they have there's a longer period of time than the 12 days. So there's not enough time for them to respond. And so the request from Mr. Zandy is to set this matter over to the 15th of August at 1 p.m. Have everything heard at that time. And I'm leaning towards continuing that temporary restraining order until we have that hearing on the 15th. So that's kind of where I'm leaning at this point. Ms. Francis, do you have what are your thoughts?
He didn't to make me aware of not having an attorney. I thought they were supposed to, and I thought I was supposed to get an option to do 1 and 2.
Yeah, it looks like Mr. Zandy, you probably haven't received it yet. It looks like his office sent out a proof of service to you yesterday. So looks like that'll be in the mail shortly.
I don't feel like that was very fair to be shock and awe. Also, yeah, the restraining order was because he was obviously he drinks a lot, and he was harassing me and the kids, and nobody could walk around the house with this man. So, and when they served him, he was drunk as well. So I don't know what else to do, I guess, at this point, but listen. So
Okay. All right. Mr. Zandy, so you heard my plan as far as setting all matters to the 15th at 1 p.m. and continuing the temporary restraining order until that time.
Yeah, and I think that makes good sense. I don't have any objection to that. I know from my client's perspective, his goal is just to have time with his kids. He misses his kids. I'm sure they miss him as well. So if we set it, I think the 15th is a good date. That gives us time to file the responsive pleadings and get an answer out, and also, I guess lessens the amount of time that he goes without seeing his kids.
Okay.
Did I not put that he needs 30 days treatment in that restraining order?
You may have asked for that. I don't know if in the order that was granted by the judge, if the judge granted that. Let me double check. I don't remember seeing that, so let me just review that.
He's an alcoholic. He drinks and drives.
So let me just take a moment and review the order. So I don't see that in the temporary order that was issued. So that's something that you can certainly address on the 15th of August. But until that time, what I'll do, the order that was entered on the 12th of July, I'll continue that until August 15th, when we hear the case again.
Okay.
So, Ms. Francis,
ma'am, if you do, I apologize, Judge. Ma'am, if you do have any questions or serve anything, just please give that to my office. You should get my notice of appearance in the mail today. And if you do are agreeable to Eric seeing the kids in any capacity between now and the 15th, please let me know.
They don't want to see him.
So you all can talk about that a little bit more once we're offline. But so Ms. Francis, just confirming for August 15th at 1 p.m. that works well with your schedule.
Which the 15th at 1 p.m.
Yes, ma'am. That's a Tuesday.
Okay.
Okay. All right. Great. We will see everybody on that date and time.
All right. Thank you.
Thank you, Your Honor.
Your Honor. This is Beth Fellows, guardian ad litem.
Good morning.
Good morning. If we could take the Wade Harlan matter, it will take all of about 2 seconds.
Okay. Yeah, I'm fine with that. So this is Cody Wade and Lacey Harlan, cause 223-483-08. Looks like Ms. Fellows is here as the guardian ad litem. I'll see if Cody Wade or Lacey Harlan are here. If you are, please speak up and let us know you're here.
I don't believe that they will be. This was a review of the payment for the GAL fees. I would like to actually apologize to the court, although it was not in front of Your Honor. We were here last week and I was having technical difficulties and could not log on. So it was Commissioner Chelsea Baldwin who set it over to this docket. But this really needs to be stricken because way back, I think in June, when I questioned whether or not the GAL fees were paid, I was mistaken. They were paid in full by both parents. So this matter is done, dealt with.
Great. That does make for a short hearing. So we'll just
Yes.
put that in the court minutes that the fee, GAL fee has been paid, and we'll just strike today's hearing.
Yes, thank you, Your Honor.
Good. Thanks for that update. I appreciate it. Okay, next let's go to the Marlene Wanzer Miranda and John Miranda matter. This is cause number 10-3505-1. I'll double check to see if we have both parties here. It looks like Marlene Wanzer, can you hear me this morning?
Yes, sir.
Okay, welcome to you. And then Mr. John Miranda, can you hear me?
Yes, sir, I can.
All right, welcome to you also. This is a motion for contempt brought by Ms. Wanzer related to medical expenses in Florida and also expenses related to travel for graduation of Hope. So I wanted to, before we get started, I wanted to ask Ms. Wanzer about the service. So let's just kind of just look at that first, because I had a question about that. And let me pull up the documents. And when I refer to service, I'm referring to the documents that Ms. Wanzer's filed and that were given to Mr. Miranda. So on, let's see, June 29th, it looks like the John Miranda was served with documents, and it says contempt hearing documents, and then it was signed by Marlene Wanzer. So question for you, Ms. Wanzer, it was not clear to me which documents were given to Mr. Miranda.
Your Honor, I mailed all the documents to him because he lives in Florida. And then I did a service to the post office, and then I turned in the receipts, and then I returned that I got a signature card and that they had signed that they had received the service. And so I turned those in.
So you submitted the return receipt, like the signed returned receipt. When did you turn that into the clerk's office?
I believe it was last week.
Okay, so I'm not seeing that. Let me check with Mr. Miranda. Mr. Miranda, did you receive documents from Ms. Wanzer related to the contempt?
I did. I got a motion for contempt hearing packet, FL all family 165.
Okay. And did you receive an order to show cause? The 2-page document.
All I got is the filed Superior Court clerk order to go to court for contempt hearing and the motion for contempt hearing.
Okay, yeah, I think that's what we're looking at. So let me touch base with Mr. Miranda. There's 2 ways to approach this. One, it's unclear to me from the record what documents Ms. Wanzer filed or gave to you. I've heard what you've said. So technically it's deficient. Also, she was the one that mailed it. The party that they themselves can't mail it. There has to be a third party. So we could come back and address this at another day and she can redo all those documents and steps, or you can waive those procedural rights and proceed today. Do you have a preference?
Your Honor, I wish to proceed today so we can be done with this.
Okay. All right. Very good. Okay. So noting that Mr. Miranda waives the deficiencies in service, we'll move forward with the hearing. So I'll hear first from Ms. Wanzer and then from Mr. Miranda. Just so you're aware, I did read the material submitted by Ms. Wanzer, and I did read the response by Mr. Miranda. So,
Ben Affleck is an okay actor. I totally agree, first of all, with your username. Definitely an okay actor. And this chat, no, it's not healthy for anyone, but it's like super healthy for a very small subset of people that I consider my family. So if you want to hang out, you're rooting for me and love me, get some help. With what? YouTube? Or my editing? I know. I need to get better. I've been working on it. Do you want to help me for free? That'd be sweet. Otherwise, yeah, no, I'm good. Lisa, do I know how to get a hold of Allie B from Tennessee? Not other than just going through different chats or the discords. Um, oh, you mean, yeah, Ben Affleck. Ben Affleck could blast me on Twitter and we could problem solved, right? Or are you talking about my braiding skills? Because first of all, I'm not a beauty YouTuber. I'm a fucking wannabe law tuber, so my braids don't have to be on. Or just going to Tennessee, Courtney. Like that's our last option, right? We'll put out a call. I'll call Allie B from Tennessee. Come hang out with me. That's what we'll say. Yeah. Also, by the way, Ben Affleck and the accountant, hot. Super hot.
Ms. Wanzer, if you want to go ahead and just state your reasons why you think contempt is appropriate.
Sure, Your Honor. Just that they moved to Florida and that John had made some pretty big promises to Hope to get her to move to Florida with him. She did not really want to go. He has, assured the Ann Height that, he would pay for her round trips to come home for vacations, which did not happen, and was found in contempt for March when she came home because he did not pay. And moving forward, going to graduation, I had asked that, Hope, pick us up, but she had a broken car. And so I said, well, can you have your dad? I don't have the money to rent cars. He made it nothing but harder for me to come. I'm on a very limited income. I'm on permanent disability. And he had stated that he would help me any way possible in accommodating me to come to Florida if I come to see her round trip. So that was that one. And I only put in for 50% of what I paid. I just thought that was fair. And also,
could I ask you a question on that, Ms. Wanzer?
Sure.
Related to your travel expenses to Florida, is there a court order that requires Mr. Miranda to pay for a rental car for travel expenses?
No, it was just stated that it was kind of a open statement there that he would just help me with accommodations when I came, if I were to come round trip.
Okay. All right. Thanks. And then why don't you tell me about the medical expenses?
The medical expenses, she's on his insurance and she got very sick a week before graduation and had to go to the ER. Also, she had, told her dad that she was sick and he was just like, whatever. And she had called me all day the day that she went, and she just, Mom, I just don't feel well. She got really sick, and then I said, well, make a doctor's appointment for tomorrow. By the end of the evening, she couldn't bear it, and I said, well, go to the ER. And so she tried to go to urgent care, and eventually she couldn't. She went to the ER and had to have a procedure. She was very sick and had to have medications for afterwards. Anyways, so this is, like I said, a week before graduation, and then she did ultimately get better, and she then John handed her, of course, the processing with the hospital and everything. So it was after graduation that they got the bill after what insurance paid, and John had handed it to her and says, here you go, kid, welcome to being an adult. And she called me kind of freaking out, Mom, what do I do? Because I just graduated. I only work part-time, and how am I supposed to pay this? It's over $1,000, I believe. So anyways, I just kind of feel like she was still in school, that he should be taking care of her.
So thank you, Ms. Wanzer. Hope turned.
Hi, Mayor. Hi, Hector.
18 on April 4th.
Yes.
And the hospitalization was middle of May, I believe, the 15th.
Middle of May, and she was still in high school. Yes.
Okay. And then the temporary child support order, I saw that the child support order related to uninsured medical expenses was dated December 14th of 2012. So that's the document that I'm looking at. Is that the same document you're looking at that relates to uninsured medical expenses?
I'm unaware about any, yeah, I think so, but there was the child support was completely stricken.
I don't see that order of 2012 was ever stricken, so it's still in effect.
All I know is that there was never any child support. John had waived it. We had decided together that we had waived it. Also, and
Is there an order that says that child support was waived?
no, we did it privately
Okay. All right.
with support enforcement.
Okay. All right. And then let me ask you, looking at that temporary child support order from December of 2012, it says that there's a division of responsibility that Ms. Wanzer would pay 31% and Mr. Miranda would pay 69%. And that order did not necessarily contemplate continuing obligations past the age 18, except for post-secondary education, where it specifically said that provision was reserved for the future. So if my understanding and assuming that order is still in effect, there's not an explicit provision that says that past age 18, the uninsured medical expense is obligatory on both parties. What's your response to that? Can you help me understand your?
Well, my response to that is that she was still in primary, she was still in high school. So if you're going to extend it through secondary school, wouldn't it? I mean, doesn't that apply through high school?
Well, the one specific thing that said that was reserved for future ruling would be post-secondary support, post-secondary schooling. So that was.
Just listen here, guys and gals. If you have a child who has a kid or if you have a child who has a medical issue while they're still in high school, but they are over 18, and you hand them a bill for that medical issue, you're a douche. You're an absolute douche. I don't give a fuck how much it costs. I mean, this doesn't come up in Canada. This is not the type of issue that comes up. Uninsured medical costs, yeah, but not. I mean, this is crazy to me. Like, you want to know how much he cares about his daughter? About as much as he cares to print out a fucking bill and hand it to her for this? Like, what the fuck? I'm baffled. Why is the judge legally looking at this and not going like, hey, yeah, but you're a douche? And also, high school should absolutely be, I don't give a fuck how old they are. If they are still in high school, there should be no change. No change. No change. Also, she should be smart right now. He never got that in writing that he didn't have to pay child support. Well, he does. I'm sorry. Learn to do your paperwork.
Reserved, so there's no explicit mention of it at that time. So the other question is the billing statement that you submitted that lists, the insurance coverage and the amount owing, says the responsible party is Hope Miranda. What's your comment on that?
Because she, of course, was the patient, so they sent it to her.
Okay.
It's under John's insurance, of course.
Okay. All right. All right, very good. What other information do you want to share about your motions for contempt?
Well, just that, that he has stated in the previous court hearing that we had in contempt, that he had made statements that he was didn't pay for Hope's plane ticket because he was providing her with a ticket to come home for the summer for an extended stay, which he hasn't. In fact, I just purchased her a ticket to come home next week.
Is that part of your motion for contempt? I didn't see that.
No, I'm just saying it shows to character of just how I can't count on his word even in paper.
Okay. All right. Thank you, Ms. Wanzer. Mr. Randall, what's your perspective on the two issues? Or I guess the one issue on the medical expenses, because I think the travel graduation expenses, there's no order that requires that. So I'm denying that motion for the contempt of that portion. So the focus is on the medical expenses at this point.
Yes, sir. So I provide insurance. I will continue to provide health insurance for Hope, my daughter, as long as I can keep her covered. But I had told her previously to schedule a doctor's appointment when she had first told me that she was having some pains. I was not like, whatever. I told her to go see our family doctor and schedule an appointment. Hope is a procrastinator and didn't do that immediately. So a day or two after, she had scheduled an appointment after talking with her mom. She never made it to that appointment because she went to the emergency room that evening. I kind of had a conversation with Hope after returning from the emergency room, just letting her know that, you know, the costs are going to be exorbitant because you went to the emergency room. Everything is, you know, it seems like almost double. And I said, you know, if you'd have gone to the doctor's appointment, something may have been able to be done at the doctor's, which would have been relatively cheaper, and the insurance would have covered a good majority of it. Granted, the insurance covered almost more than 90% of the emergency room, so that was great. I didn't think that it was out of question to help my daughter understand that the process of going to the emergency room, that a bill comes along with that. I asked her to contact the hospital, let them know the situation that she is in, that she just turned 18. She's still, you know, just about to graduate from high school, in the hopes that maybe they would either waive this or move it.
Well, okay. What time is it in Tennessee though, you guys? 10:40. So it's pretty late. Allie B doesn't always come in here at night. But I'm gonna look through my email right now and just double check and make sure that I don't have a more direct line from her. And oh, I might actually. Let's just keep watching this right now. Just remember, guys, sometimes people have moments.
But you know, to a minimal payback. That was my ultimate hope for it, Your Honor. And in asking Hope to take charge of that, it was, you know, she would like to be treated as an adult. And, you know, with the treatment of, you know, asking to be treated like an adult comes this responsibility. So I asked her to take care of it. Next thing I know, I'm being served with papers as far as the contempt hearing here.
Okay, thank you. Let me ask you, if I may. So the temporary child support order of December 2012 indicates that there's a division of responsibility for uninsured medical expenses, a 31-69 split. My question, I guess, is that as the person providing the insurance to the insured, Hope, if there's a remaining balance, the obliger or the party responsible for that is the policyholder, is it not?
I would say that ultimately, yes, they would come after me if Hope didn't pay it. Yes.
Right. Yeah. If Hope decides not to pay it, then they're going to come after you for paying.
We're good, guys. I think we've established contact. We good. The internet has worked. Nigel is here. Good evening, everyone. I hope you're well too, Nigel. Thank you for coming. Taser, both parents court ordered the child to move out, Courtney. I think that's probably there.
Payment.
That is correct.
So, and this just happened in May, and now we're just barely into August. Okay. Okay. All right. That's helpful. Let me just look at one item here.
A 31-69 split is
Your Honor, when you have a second, I
favorite.
have one more question for you.
I'm ready. Go ahead.
I was just wondering, you know, now that Hope is 18, has graduated high school, and, you know, she is working, you know, when is she actually considered an adult, and where does our parenting agreement kind of end when she is, you know, considered an adult?
So there's a parenting plan that was issued on September 30th of 2022. And then when a person turns 18, the parenting plan is done, because she's a person of age of majority at this point. So she's no longer a minor.
Thank you, sir.
All right. Ms. Wanzer, do you have any just brief response?
Not really, Your Honor, just that, I've been on disability now for a few years and I live on, minimal funds, obviously, because they don't pay very much. So I just feel like, John has taken every advantage that he can of me in the past and still does. So that's just, that's pretty much it.
Okay, all right, thank you. All right, so there are two grounds which Ms. Wanzer brought a motion for contempt. The first was the travel expenses to Florida. So any order or any motion for contempt necessarily needs to be based on a court order. And the allegation needs to be that a person violated or did not follow that court order. So as I mentioned earlier, there was no court order that required Mr. Miranda to make any expenditures related to travel for the graduation trip or what have you. So I'll deny that portion of the contempt. The other portion is that the medical expenses for the emergency room visit. It sounds like she wasn't doing well for a period of time. There was encouragement to take a different action. She got the help that she needed, whether it was timely or maybe a little later than hoped for. And then there's about a $1,100 bill that's outstanding. So the child support and health insurance is a little bit different in that health insurance generally parents can keep their children on their coverage up until about age 25 is pretty common across the country. And here we have Mr. Miranda's indicating that, he's the obliger, he's the contracting party with the insurance company. So eventually they would come after him for the balance. But here there is an existing temporary child support order. It's temporary and it's old, but it's from 2012. It requires Ms. Wanzer to pay child support, but we're not here on that issue. We're here on that says that if there's uninsured medical expenses, then there's a split of 31% and 69%. So there's no clear indication that the child support obligation ends at age 18, because it's often common that children will turn 18 and still be involved in educational pursuits at the secondary level, high school. So here, I think that obligation continues. So both parties are responsible for the $1,049.89 in a calculus of 31% of Ms. Wanzer and 69% of Mr. Miranda. So that's what the parties are obligated to pay the hospital. As far as the contempt, I think there needs to be a willful and bad faith refusal to comply with the court order. So here, the court order is over almost 11 years old. There was in a relatively short period of time from the provision of services until the contempt was filed. There was some question related to age of majority and the like. So I'm going to deny the contempt, but just make clear that the parties are responsible in that percentage division for payment to the hospital for the services rendered to Hope. So I'm denying both motions for contempt. However, both parties kind of have a clear idea of what the responsibility is under the child support order from 2012, that 31% to Ms. Wanzer and 69% to Mr. Miranda. Do the parties have any questions, Ms. Wanzer or Mr. Miranda?
No, sir.
Yeah, Your Honor, actually I do. How am I, I live on $1,000 a month. So paying $300, what am I looking at there?
So that would be something that you could check with the hospital and work out payment arrangements through them. I know a lot of hospitals have charitable causes and they have some flexibility in their payment plans, and they work with people. When people don't reach out to them, that's when they get concerned, I think I've seen in the past, but that would be your responsibility to work out something with the hospital.
Your Honor, if I may, just to bring it up, is Hope gets a stipend of Social Security benefits.
Your Honor,
that should probably go to that.
No, that Your Honor, I object.
So Ms. Wanzer, as a general rule in my courtroom, I allow people to finish, and your objection is denied. There's not a legal basis for the objection. Mr. Miranda, you can finish your thought.
Yeah, so basically what I was saying is Hope gets a stipend from the Social Security that she gets along with food stamps that are provided. I watched this child since she has been getting it, because I have nothing to do with it, waste this money. So I think it would be very appropriate for this to go forward to that. I do understand your ruling is I'm obligated for the 69%, and if you rule I'm obligated to that, I will pay that bill to that. But Hope being an adult should have some kind of responsibility towards this.
Okay, thanks. So I won't make a ruling on that. That's something that the parties can work through. I get where the parties are coming from and teaching responsibility and accountability and financial wherewithal. I get that. So I won't rule on that. The parties can figure that out. Ms. Wanzer, any last comments?
Yes, I do want John to know that she was cut off months ago from Social Security.
Okay.
And that was as soon as she was 18. She no longer got any more money.
Okay. All right. All right. Thank you both. That'll conclude today's hearing.
Thank you, Your Honor.
What a douche. Yeah, how much
Next,
water
let's
does she
go
use in the
to
shower?
Shanice Watts and Brandon Lovato. 223-30708 is the cause. Let's see if Shanice Watts.
Like, seriously, that's either he's being petty to the daughter or he's being petty to the mother. Either or, he is being petty. And I hope I doubt it, because he seemed quite smarmy and just okay in being a douche. But in reality, like, what the fuck? Like, you don't. Oh my god. These people. It's crazy. It's crazy. Like, that poor girl, she's gonna tell that story forever. When I turned 18, I had to go to the emergency room because I was sick, and my dad sent me the bill. And I had to pay for it. And my mom went to court, and the judge said that my mom and my dad had to split the bill, but that I had to pay for everything going forward. And maybe she doesn't talk like that. And honestly, it's not even funny. It's not her that I should be making fun of. It's him. Because yet again, like, I have a daughter. She's 15 years old. Do you think I think my obligation ends in 3 years? I don't. I have absolutely no reckonings that I will be not giving her money. Like, it's so baffling to me. Like, what? Again, I don't know who he's trying to make feel bad. At this point, he's made me feel bad, and I don't like it.
So are you on the line today, Shanice?
Yes, I am.
All right. Welcome to you, Ms. Watts. And Brandon.
Child support obligations end eventually. But, like, supporting your child obligations never end. Tell that to my mom.
Brandon Lovato, are you on the line today? Brandon Lovato?
Yes, Your Honor.
Okay, well, welcome to both of you. All right, so let me just double check. This is Ms. Watts' motion for adequate cause to modify a parenting plan. I want to first talk about service. As far as proof of service, I did not see proof of service of the motion papers served upon Mr. Lovato. Ms. Watts, did you provide some type of declaration or statement that you served X, Y, and Z documents to Mr. Lovato on date A, B, or C?
No, so I didn't, but we had spoke and he said that he already knew about the court date and he already had read the paperwork. So and he said he would be here today. So.
Okay. All right. Let me check with you, Mr. Lovato. There's procedural rights for service that require proof of service that says, hey, I, as the moving party, served a number of documents or a document upon the responding party on such and such a date. So you can waive that right to have that done correctly. And then Ms. Watts could reserve things and do that properly, and then we could come back at another time. or you could waive those procedural rights related to service, and we could hear the matter today. So I don't care which way we go. Either is fine. So do you have a preference?
Yeah, I already paid to get them from the court, so we can just move forward today.
Okay. All right. Very good. We'll note that Mr. Lovato is waiving his rights, procedural rights for service for this particular hearing. It looks like he received the information that was necessary. And then having resolved that issue, let me check with Mr. Lovato. Mr. Lovato, I read the viewpoint and information from Ms. Watts. Did you submit any documentation for the court to review?
No, because I had my girls for the summer and I just didn't really have much time to. By the time I actually found out about the court date was after it was already scheduled. After it was I think there was a court on the 11th, and I wasn't aware of that. And so I didn't even start getting the paperwork until like about a week and a half ago. And so I just haven't had time, but I did read her complaint.
Okay. All right. Well, so do you feel like you had adequate time to prepare a written response and submit it to the court so your view could be read and digested?
I haven't had time to do a written response now.
Okay. Do you want to provide a written response?
I don't think I'm going to really need one. We've kind of already talked everything out. So, I mean, unless she's trying to keep the original motion.
Okay. Well, let's hear from Ms. Watts. Your motion is for adequate cause related to the parenting plan and the move to Alabama and the like. So I'll hear from you, Ms. Watts, what your vantage point is in relationship to kind of what Mr. Lovato was saying.
Yeah, so when we first did our parenting plan, we did 50-50 in the state of Washington. The girls go to Kelso. So then he gave up his rental here and then moved fully to Alabama. And so we couldn't remain doing.
Love you most, like my thing says, Melanie. Also, hi, Flusha. Never trust a dude in a bow tie. I sort of believe that because of Judge Kim. Little bits. And this judge has been making some weird calls. I'm just going to say it.
50-50 with him living in Alabama. The girls are there right now for the summer. So we were going to they stay here during school and then go there in the summer. Our youngest, Kaylee, she's been having a little bit of like behavioral stuff going on. So we actually talked it out to where we're going to see, because she's been fighting a lot with her sisters and stuff, if she stayed with Brandon for a little bit longer. So the other two would come back before school started, but then Kaylee would stay. She would stay in Alabama for a little bit longer to see if we can see if her behavioral stuff gets a little bit better, I guess. We're just going to do it, just see if it helps her at all. So then we're just going to do that for a couple months and see. And then if she's better, then she will just stay there and then I'll get her in summer. And if it's not better, then she's going to come back here and then do school here.
Okay. Okay. All right. Thank you. Appreciate that explanation. Mr. Lovato, is that the plan that you and Ms. Watts have agreed upon?
Yes, that's what we agreed upon.
Okay. So let me just go back just kind of procedurally why we're here today, that there's a motion for adequate cause to modify the parenting plan. So that's kind of step one. Step two would be the actual modification of the parenting plan, which it sounds like the parties have pretty much agreed upon. So I'm inclined to grant the motion for adequate cause because there's been a substantial change in the position of the parties based on the move to Alabama, which makes the 50-50 parenting plan impractical. So I'm in a position to approve that order for adequate cause. And then the next step is the actual modification of the parenting plan that I don't know if the parties have drafted a parenting plan that reflects your agreement that talks about, school, the children would be with Ms. Watts, and during the summer they'd be with Mr. Lovato, and with kind of the nuanced with the one child and staying a little bit longer with dad.
Yeah, so we haven't done that yet because we just recently started talking about it. So I think we will have to submit a new one just with the new changes and stuff, with Kaylee staying there a little bit longer and evaluating her behavior and whatnot.
Okay. Let me ask the parties if I can submit the order on adequate cause and get that filed. And then I think it would be helpful, and you can tell me otherwise if it's not, to set a date, maybe in a month or so, or 6 weeks, to allow the parties to work on an order that reflects your agreement. And then we could come on that date. And if you've already submitted it, then it would be signed off on if both parties have signed it. If both parties have not agreed on that revised parenting plan, then we would be here in 4 to 6 weeks to address the issue and figure it out. So
Yeah,
what do you think about that?
Well, the only issue, Your Honor, is in order for me to have the youngest registered for school down here, I'll need to have paperwork showing that she's living with me with the court. Because the current parenting plan would show her as living in Washington, and I wouldn't be able to register.
Gotcha. So you're maybe looking at more of a expedited time frame.
Yes.
When does school start for the kids there in Alabama?
It starts on the 12th of August.
12th of August.
Oh.
Jesus.
That's soon.
Yes, very soon.
So we have one more date, which would basically be in a week, which we could come back and hopefully the parties have kind of hashed out and worked through the parenting plan. And then if there's any fine details, then we could probably address those on next week's docket. Ms. Watts, how does that look for you?
Yeah, that works. The only other thing that I had questions about is the last time we went to
Uploading.
court.
Sorry, Melanie. Uploading a stream is different than downloading. Like at my other place, I have better internet that we pay for because he's a gamer and he appreciates a high upload speed. So, yeah. And this house is just different. Like I'm farther away from the router. There's so many things going on. I wish I could be hardwired in. This computer I have doesn't have a hardwire. Regardless, let's keep watching. It's still so hot, you guys. I'm going to do a temperature check here in a second, see what temp it is. Whew.
About the girls' Social Security, it was supposed to be in like a joint account for both of us to be able to pull from. That still hasn't been worked out since he moved to Alabama. So is there a way that we can get that worked out too?
So yeah, let's pause on the Social Security thing just for 1 second. Let me just confirm with Mr. Lovato if you're available next week, the 10th at 9 a.m.
Yes, I will be available.
Okay. Then the question raised by Ms. Watts, you said at the last hearing, which was when, back in March?
Yes.
That there was some type of agreement related to Social Security, correct?
Yes.
Yes, the girls' Social Security was supposed to be put into a joint account that me and Shanice held together.
Okay. And is that in place? Is that happening?
No, there was things that happened right before we were going to create the account, and so it made it not necessary. But turned out to be necessary in the end after all. So.
Yeah, Your Honor, because after he moved to Alabama, he kind of was like playing games with the money. Like, because since I had them full time, we agreed that he was going to just give me all of it since he didn't even have the kids at all. And it kind of was like a struggle to even get it all from him at times. So I just want to make sure that like I don't have to like go through him to even be able to like get the girls' money.
So where's the money now?
It goes straight into his account.
Okay. And you wanted to have it to go into a joint account.
Correct. Yes.
Okay. So I'm just reviewing the minutes from March 30th. So it says court questions regarding Social Security benefits. Mr. Lovato responds, suggests joint account. Ms. Lovato responds regarding paying for the oldest child and half of other children. Court addresses the party regarding deviation, residential credit. Goes on, talks about TANF. Then the court orders transfer payment. Says court orders joint account be set up for each child for the Social Security benefit. That I'm not sure if that was reduced to a court order, that portion of it. You know, there's the verbal order and then there's the reduction to paper. And I'm not, do either party know if that was reduced to writing?
It was never put in the actual order itself, no.
Okay.
Jonathan,
Do you
you're
agree
funny.
with that, Ms. Watts?
Yes.
Okay. So often what happens, the court relies heavily upon the parties or attorneys to draft orders due to just sheer number of cases coming through. So if that was not done, that could be done now and retroactive to March 30th, basically just a memorialization of that order. Does either party have any concerns related to that?
No.
No, Your Honor.
Okay. So let me just put this here. Just give me just a moment to jot this down. And the joint account would be between Ms. Watts and Mr. Lovato, correct?
Yes.
All right.
So since I will have our two full-time, because when we first initially did our child support order or whatever, I had Courtney full-time, and then the other two would do 50, like half on, half, or week on, week off with myself and Brandon. Since he had moved, now he lives in Alabama, I now will have Courtney and my middle child Bailey full-time, and then them go there for the summer, and then Kaylee will be with him full-time until we figure out her situation.
Right.
So as far as that, because he pays $400 for just Courtney since I have her full-time, but now that I have Bailey full-time, do I need to like, because I don't think it would be fair to have him like also like share that there goes Social Security and be able to touch them when I have them full-time.
So that sounds like that maybe require some type of specific motion requesting the relief based on the change that has occurred. Your motion today for adequate cause addresses the parenting plan. Obviously, parenting plans can affect child support. The child support issue is not ripe because we don't have financial information from either party, any proposed worksheets, proposed orders. We don't have any of that. So that may be something that a continued or additional motion would be necessary to address that. And then all the parties can supply the information. That's probably not going to happen by next week, but that would be something that the parties, if you want to talk about that, you can certainly talk about it and come to an agreement. If you can't come to an agreement, then a motion can be brought by either party to address it.
Okay, sounds good.
Okay, so what I'm going to do, I'm going to submit and sign an adequate cause order making a finding that there is a substantial change, a major substantial change, and that then there will also draft an order related to the joint account that it needs to be established for each child to receive and access Social Security benefits. And then we're setting this matter over to the 10th at 9 a.m. for submission of the parenting plan. That's what I know. Do the parties have any questions?
No, Your Honor.
No.
Okay, I'll make sure both of those orders are drafted and submitted today, and you can access them. And then we'll see each other on the 10th at 9 a.m. Maybe a different judicial officer, but the hope is that the parties can hammer out that parenting plan with the new details and the new situation. And if not, if there's the finer points that you can't come to agreement, then that could be addressed at the next hearing. If you can address everything, fantastic. You can submit it signed by both parties, and then we can go from there. It would be nice if once you've drafted that parenting plan, to submit it to the court so the court can look at it, what areas there are of agreement, and if there are any areas of disagreement, then the court would at least be apprised of what the issues are. So if you can get that far in your progress, that'd be fantastic. And hopefully we can have this resolved prior to school starting on the 12th.
Thank you.
Great.
All right,
We'll
thank you.
see everybody next week. Thanks.
Thanks.
Next I have Justin Yokel.
Fine. One more. He is so boring. His voice is so boring. But we'll watch this Justin Yokel because the name is tickling. It is so hot, y'all. Oh my God. It's so hot. I said y'all. And I say y'all all the time. But seriously, it's
And Courtney Geyer, cause 223440-08. And there, Ms. Turnbull is the guardian ad litem. She's present. And I'll ask if Justin Yokel, if you're on the line, please state your name.
Justin Yokel.
Right, welcome to you, Mr. Yokel. And Courtney Geyer, if you're on the line, please state your name.
Courtney Geyer.
Okay, well, welcome to you, Ms. Geyer. All right, we're here for review of the Ms. Turnbull's report, which was submitted on July 17th, 2023, that made some recommendations. I'll ask Ms. Turnbull, do you have any comments related to your report that you submitted?
Not at this time.
Okay, all right, and then let me hear from the parties what your take is on the guardian ad litem's recommendation related to the parenting plan of Talon. So I'll hear from the petitioner, Mr. Yokel, first, and I'll hear from the respondent, Ms. Geyer, next. Mr. Yokel.
There was a few things on there that I didn't agree with or thought that it gave the whole spectrum of what's been going on, and yeah, I just yeah, obviously I want to be involved more with my son, so it's I didn't agree, no.
Okay, maybe I can just kind of walk through the recommendations, and then you can give me your take on it. So first recommendation is that primary custody be granted to Ms. Geyer, and that you would have visitation. What's your take on that?
I don't necessarily contest that. I just I guess I'm more about the supervised visits. I don't think that it a lot of the stuff that was talked about was, kind of issues between me and his mom, from the past. Like I said, I just Talon's my number one concern. I'm not saying that I wouldn't do anything, because I would do anything for him, and if it requires me to do that, that's what I'm going to do. But I just want what's best for him, and I just want everything to just to be as normal as it can be, and just get through this is what I'm hoping.
Okay. All right. So your main concern is the supervised visitation recommendation. You indicated that if that has to be, then fine, you'll do it because your relationship with Talon is really important. But if you had your druthers, you would have it be different and would not be supervised, correct?
Yes, sir, Your Honor.
Okay. And then there was recommendations for mental health evaluation and SUD evaluation and any follow-up treatment. What are your takes on those?
I mean, I have no problem. I could UA today. And as far as mental health, I mean, it couldn't hurt. I don't, I'd like to have some counseling, with my son if possible, or just, I mean, whatever can help, I'm for. I'm not, against anything that's gonna, benefit me or him. So.
Okay.
Yeah.
All right. So okay. So with SUD evaluation, you're okay with doing that, and then the mental health evaluation, your indication is that your focus is to build a better relationship with your child, and so it couldn't hurt, and so you'd be open to doing that.
Yeah, and what exactly is the SUD?
Yeah, and substance use disorder evaluation, basically,
Okay.
if there's any concerns related to substances and getting away of life and the like, then they would do an evaluation, and what the evaluator determines.
Do they do evaluations to see if watching court on YouTube gets in the way of your life? Or becomes your life? Also, yes, med check, folks. Take your meds. Name your strain. Take your meds. Look at me. I'm wearing. It feels better though. My hair off my neck is integral. Do I have air conditioning? No, I don't. I'm putting in a phone call right now. Let's see where I can go tonight.
Determines is appropriate, then that would be the recommendation for treatment. And the treatment may be none, or the treatment may be take an 8-hour class, or it could be, take intensive outpatient. I mean, it could, or it's, if things are really bad, it could be.
Yes, Hector, that is here on Sundays. We do the court watching anonymous meetings on Sundays. Barry Alamo dab time for Courtney. Also, who was it saying earlier that I'm so unhealthy? I don't care.
Inpatient treatment, so depends on the evaluator, and they take in information from a lot of different parties. They talk to you, get your take on things, and then they come up with a recommendation.
Okay. Yeah.
Okay. All right. Okay. I appreciate your input, Mr. Yokel. Ms. Geyer, what's your input related to the guardian ad litem report and recommendations?
Yeah, I agree with the guardian ad litem's report.
Okay.
I know there was some say that he was clean off heroin for 2 years. I want to bring up that I have been concerned since heroin, it went to fentanyl. I'm very concerned for my son around or come across that after hearing how deadly it can be. So that is my high concern.
Okay. All right. Thank you, Ms. Geyer. Ms. Turnbull, do you have any comments?
Yeah, I wasn't aware of that concern until just recently, after I concluded my report. But if that is a concern, I would agree that that's, of course, that could be very deadly very quickly. And I certainly wouldn't want talent around that.
Okay. Thank you. Yeah, and I think Mr. Yokel indicated that he's willing to do that SUD treatment.
Ugh, fentanyl's bad. Also, but Prissy, she's never taken it before, and she's got a party tomorrow, so she can't. You can't do it tonight, Melanie. You just gotta have to not sleep till the party. And then after the party, you can take it, but you can't take it first. Just sorry, buds. That's the way it is. You can take some edibles if you want and conk out for a bit, but no Ambien tonight. Says Dr. Dr. KCC. Doxing myself worse than Mikey does.
Treatment and evaluation, and if there's concerns related to fentanyl, obviously fentanyl is an absolutely terrifying drug because of its impacts to the living, and it causes a lot of overdose death. We just lost a client in drug court just last weekend, and it's rampant. It's an absolute scourge. And so if there's any concerns related to that, hopefully that they're not, and if there are, then that could be addressed by the SUD evaluation and the like. So yeah, I think everybody kind of shares in that concern, including Mr. Yokel, because everybody wants Talon to be fine and safe and well. Okay. All right.
I also have one more question.
Yeah, go ahead.
I have this restraining order in place, and just like 2 days ago, he texted me asking, "Hey Dad, hey Talon, it's Dad, just trying to get a hold of you." He's not writing my name, but he's writing my phone. What are the? I guess I need guidelines, or I don't unclear. Like, I thought he was not supposed to be writing me, so reaching out for Talon even on my phone, that's still not okay, right?
So the order, when was the order entered? Do you remember?
For the restraining order, I don't. I'm at work. I don't have it with me.
Mr. Yokel, do you remember the approximate time frame?
It was I'd say about a month ago, maybe.
About a month, okay. Let's see.
I have no, no,
We were setting
I
up a
wasn't trying
road trip. We were all deciding who gets picked up first down to Tennessee. It was me, because I'm the furthest away. Although I'll be near there next week. But I'm glad you're here, friend.
contact her. I don't have any, I'm not, I didn't know how to reach my son. I haven't talked to him for a while. He's used to seeing me, you know, and it's been kind of hard not seeing him, so.
Sure. Let me ask Ms. Turnbull, I don't recall specifically if you had any recommendations related to that aspect of as far as communication concerning the child. Did you make any recommendations on that?
I would recommend it be supervised for some period of time because there has been a history of inappropriate involvement of adult issues, you know, that Talon's been involved in, and I am concerned about that.
Okay, so if, as far as if there was a need as far as communication regarding the child, you know, setting up times for visitations and the like, are you suggesting, Mr. Turnbull, that there'd be an exception, or that there would be a third party that would be the communicator?
For supervised visitation, I think, well, I would recommend professionally supervised visitation, at least for some period of time, so that we can have some feedback from the professional supervisor as to the nature of the communication between the parent and the child. And
more to the point, as far as like, you know, setting up like, okay, it's going to be Tuesday at 4 p.m. How is that? How does the communication between the parties happen? Is it through a third party or with that restraining order in place? How does that work?
Oh, yes, a third party.
Okay.
Yeah, I prefer a third party as well.
Okay. All right. Ms. Geyer, does that address your concern? Basically, it'd be, you know, if there's a restraining order in place, that needs to be obeyed. And if there's communication involving the child, then if Mr. Yokel needed to communicate with you regarding the child, then he could ask a third party to communicate with you solely on the issue of the well-being of the child.
Yes, the third party is fine with me. I think I put in there something about the app I heard about you guys having that, but obviously there's the restraining order, but regarding Talon once, if there was an app or something you guys had that, like, with the wizard, is that what it's
Our Family
Yeah,
Wizard?
there's a variety of them. There's one called Talking Parents. There's another called Our Family Wizard. And it's basically an app-based subscription service where the parties can communicate. Everything's recorded, and so you communicate.
That's only on Our Family Wizard, Judge. App Close is not quite as robust as Our Family Wizard. We've talked before about how I want Our Family Wizard to sponsor this channel. I think that I have some killer ideas. Killer ideas. Hi, Georgia Peach. Hope you're doing well. Yeah. Let's let this end here, play out, and then we'll see where we get.
With the children about the child. You can send information, you know, take a snapshot of a doctor's report or a school report and share that information, and everything's recorded. And so it's a really good tool because it keeps everybody just honest and straightforward. There is a cost. I'm not exactly sure. There's an initial kind of setup fee. I think it's like $25. And then there's a monthly fee of maybe $6 or $7. Ms. Turnbull may know better than I, but that's kind of what I remember. So that's there wasn't a specific recommendation of that. Let me just ask Mr. Yokel what your thoughts are about that type of communication tool.
Yeah, as long as I don't have to talk with her, I'm all for it. My main concern is Talon, and yeah, that's just that's why I'm here.
Okay. All right, thanks.
Maybe that's something we could add in, you know, once we get a few supervised visits under our belt.
Yeah, I think that's probably a suggestion well taken. Okay, so it sounds like, you know, from hearing from Mr. Yokel and Ms. Geyer and Ms. Turnbull, There's no strong opposition to the recommendation that Ms. Geyer serve as the primary custodial parent. So I'll name her as such, as the primary custodial parent of Talon. There's disagreement here between the parties from Mr. Yokel and Ms. Geyer and Ms. Turnbull related to what visitation should look like and whether it should be supervised. I think, based on the information contained in the report and from collateral sources, there's positive and negative, on both sides. I do think that the recommendation for supervised visitation, at least for a period of time, is well taken. That doesn't mean that it's going to last forever. On the contrary, what the hope is that those supervised visitations will occur. They'll go super great, and that once those have occurred for a few weeks or a month or 2 months, what have you, then Mr. Yokel could come back to court and say, hey, things are going awesome. Look at these notes from the supervisor. I would like to move to unsupervised visitation. And so I think there's enough concerns initially that we need to have kind of that proving period or proving ground for a bit, and then we could move to look at doing something different. So I'm going to adopt that. I'm going to adopt the supervised, professionally supervised visitation for up to 4 hours weekly. And then the visitation supervisor will take notes, and those notes will need to be submitted and sent. Mr. Yokel, that you'll be in charge of that. If you could please get those notes, and then you'd file it with the court, and then send a copy to Ms. Geyer. So that will occur, and then it doesn't sound like there's any disagreement with the recommendation for the mental health evaluation and the SUD evaluation and any recommended treatment for both. I think that would be a help and a support for the relationship and for Talon. So I'll adopt those. And then regarding the communication with each other with the existence of a restraining order, I think it's important that there be opportunities for the parties to communicate related to Talon, but not directly. So it sounds like everyone's okay with the third party being the kind of the go-between Mr. Yokel and Ms. Geyer. So I'll carve out that exception in the parenting plan. In the future, when we come back, we could certainly address one of those apps, one of those parenting apps that allows the parties to communicate. So if you want to look at that in the meantime, you can pull that up and just do a quick web search, and you can find a variety of different ones. But the ones I'm familiar with are Our Family Wizard and Talking Parents. You can take a look at that. So that's what I'll adopt at this point. Primary custody with Ms. Geyer, a visitation for Mr. Yokel on a weekly basis, up to 4 hours weekly, professionally supervised. And then Mr. Yokel, if you'll please make sure that you get those visitation notes and to the court and to Ms. Geyer in support of your motion. I assume your forthcoming motion for unsupervised visitation, the mental health evaluation. If you need some assistance of where to do that or where to find resources, Ms. Turnbull, do you have some suggestions of where he could turn to find that information?
I don't care. I'm sorry. We're trying. We're done. That's it. I am so hot, and it's like both hot, sexy, and hot. My makeup is starting to melt. This is indeed my weight loss method for Florida, because I guess that's what's happening. No, seriously, I am literally very hot. I'm totally fine. I've already put out a message. I've been like, hey, your room got AC, baby. Let's talk. Oh, my neck just cracked. Anyways, seriously, you guys, what I'm gonna do right now actually is, yeah, somebody Amazon me a fan. Y'all know the PF. Oh, I'm seriously, like, I'm actually sweating. Oh, and I'm almost at my 10,000 steps for the day. Right. So that judge literally was like a sedative. His voice was a sedative. There was some fucking crazy shit that happened in that, and it was just crazy. Also, I'll just tell you the temperature right now because I swapped it over. Oh my God. This is a lie. This is a lie. It says that it is 69 degrees. Well, I just think that's a lie. I just think it's a lie. 69 would feel better than this. It would feel better. You guys, what would make me exceptionally happy right now is if we all work together to get. I'm fucking sweltering. Holy shit. That's the 69 split, Hector. No, but seriously, we're gonna name this episode's gonna be called the 69 split. If we could get Credence and Mikey over 20K, it's like so close. It means more to me than my channel numbers right now, for some reason. How am I gonna survive in Florida? In a pool? Is that the right answer? In the pool? I mean, I've traveled the world. I've been in hot places before, but usually they have AC, you know? Um, I'll survive. I will survive. Hydrate, exactly. I don't know if people in court's going on tonight. Sashina, I'm so sorry about that. If you turned on the volume and that she can't even hear me because she's got no volume, so it's not even gonna help her. I was gonna say like if she turned on the volume, I'll scream at her, but now I've already ruined it. Can't scare her. Crackheads. Y'all are so funny. You make me laugh so much. I will make it. I'm gonna be fine. Are y'all kidding? I got lost in Turkey, Istanbul, Turkey, by myself. I mean, it was hot as fuck in Turkey, I'll tell you that much. Ooh, there's my neighbors. Okay. Um, well, I might be spoiled or I might be stupid. I'm going to Texas next week, so we will see. More details on that coming. Okay. I gotta get going. Oh, Sashina did have a lovely concert last night. She went to Cake by the Ocean. No, not Cake by the Ocean. Somebody's honking. Who's everybody's good. Nobody's bad. I know. Are you guys talking to me? You want me to cool down? Oh, I'll be fine. No, I got somebody with AC. I'm messaging right now. I'm leaving this joint. I'll be coming to you from somewhere else tomorrow. I love you all. I'll talk to you later. Go to the Discord. Be good. Go and sub to Credence and Mikey with all the channels that you have. I'm being serious. You know you've got other channels out there. Other users. Go get them. Sub to them. They're close. Love you guys. I'll talk to you tomorrow. Bye. How fucking sweaty I am. Holy shit. Well, it's good timing. The computer's just fucking. The computer's as hot as I am right now, guys. I love y'all. No worries, Melanie. I do expect a pizza tomorrow. If you're making 41 shouldn't be a problem. I'll talk to you guys tomorrow. Bye.